Welcome back. Today we're going to begin a discussion of Article 3 of the Constitution, the Judiciary Article. The discussion that we're going to have in this session and the next one corresponds to Chapter 6 of the book, America's Constitution, a biography. The chapter is called Judges and Juries, and it opens with a picture of the famous John Marshall, the great John Marshall, perhaps the greatest Chief Justice in the history of the United States. And in the next session, I'll tell you a little bit about this picture and how it sums up many of the themes of this segment, this chapter, Judges and Juries, many of the themes of Article 3. But before we get to that, you may be wondering why there's only one chapter on the judiciary. Remember that after our chapter on the preamble, the first couple of lectures of this part of the course, we had actually 2 chapters on Article 1, the legislature. So 4 lectures on that. We had 2 chapters, again, 4 lectures on Article 2, the presidency, but we've only got 1 chapter on the judges. And in fact, actually, they have to share that chapter with the juries, as indeed in Article 3, judges share pride of place with juries. So what's up with that? Why less attention to the judiciary in this walk through the written Constitution? And the answer is because there's less attention in the written Constitution itself to judges. It's Article 3 out of 3. And in fact, there's less text in Article 3. It's the shortest article of the 3 big ones. The legislature gets the most attention. It's first and longest. The executive is second and second longest. And as I said, the judiciary is third out of 3. And the federal judges who feature prominently in Article 3 actually have to share the stage with juries who can be seen, as we're going to talk about a little bit more, as the lower house in a sense of a bicameral judiciary. So just as there's a bicameral legislature with an upper house, a Senate, and a lower house, the House of Representatives, are kind of a bicameral judiciary. With the upper house of judges selected in more refined ways, a small group of rather elite folk, and the lower house, a more populist house, corresponding perhaps to the House of Representatives, the lower house of the framers' judiciary, at least, of the original Constitution's judiciary, involves juries. So one question really to begin with is, why did the Constitution, why did the framers treat the judiciary least and last? Why did they make them third out of 3? And I think the answer begins with the American Revolution. You can't understand our Constitution without understanding our history. Our history as a people is, to a very considerable extent, the history of our wars, and the Constitution is a reflection of our wars. The original Constitution is a reflection of the American Revolution. As we're going to see, after the Civil War, the Constitution is going to be transformed with 3 important amendments, the 13th, 14th, and 15th Amendments. And in the 20th century, actually, wars, both World War I and World War II and the Cold War, will be reflected in the written text. So here's the key fact you need to understand about Articles 1 and 2 and how they were affected by the American Revolution, and then we'll come to Article 3. Article 1, big idea. This is going to be, Congress is going to have the power to tax and regulate, and precisely because of that, this new Congress under Article 1 is going to have to be much more representative than the old Congress under the Articles of Confederation. The old Congress couldn't tax individuals, couldn't pass laws as such, directly regulating individuals, and so it didn't need to be picked by individuals. But since the new Congress is going to be able to tax individuals, is going to be able to regulate individuals, it has to be representative of individuals. Why? Because that's what the American Revolution was all about. No taxation without representation. Parliament had the pretension to purport to try to tax and regulate Americans, even though Americans didn't vote for Parliament. That was illegitimate. That was one of the basic rallying cries of the American Revolution. These guys whom we're not voting for shouldn't get to directly regulate our internal affairs and shouldn't get to tax us. That's the American position as of 1776. So that's what the Revolution is all about, and you see the reflection of that in Article 1. Now, the Declaration of Independence is also declaring independence from the king. George III was viewed by Americans as a tyrant, a despot, and Article 2 is a reflection of how we don't want our president to be like England's king. We don't want our George Washington, to look like England's George III. And so we try to structure a presidency that has some of the virtues of the English monarchy: stability at its best, the English monarchy at its best, stability in foreign affairs, a strong military leadership and commitment to national security, but with all sorts of democratic safeguards of election and impeachment and checks and balances and the like. So Article 1 reflects the American Revolution. Congress has to be representative. Article 2 reflects the American Revolution. We want a president who's very strong, like a king, but isn't going to be tyrannical, like a king, isn't going to be possibly an idiot or stupid, like a king can be, because in England you're just born to the position, and maybe you're just really not, frankly, equipped to govern, but there you have it. You're a king nonetheless. And America's Constitution in Articles 1 and 2 are a reflection of the American Revolution. So, too, with Article 3. Here's the payoff point. That judges in the colonies generally were not patriot leaders. They were picked by the king in most of the colonies, whereas local legislatures were picked by the citizenry, and governors in many of the states at least were picked by the citizenry. Not in all the states, but in some of them they were picked by the citizenry. But judges generally in most of the states were picked by the crown. They were loyal to King George. The payoff fact is, at the time of the American Revolution, the chief judges in 10 of the 13 colonies sided with George III and not George Washington. So judges are not the heroes of the American Revolution. Local militias are. Local juries are playing an important role in resisting parliamentary taxation by sort of acquitting tax smugglers and tax cheats and custom smugglers and the like. So juries are the heroes of the American Revolution. Local assemblies that mobilize the colonists are heroes of the American Revolution. Local militias are seen as very important in this process. Lexington and Concord and Bunker Hill. George Washington is a hero of the Revolution. Judges, not so much. Now, by the time of the Philadelphia Convention in 1787, 11 years after the Declaration of Independence, we've had a regime in which now actually the colonies have become self-governing states, and the king isn't picking the judges. In fact, so Americans are picking their own judges, and so you might think that the time is right for a more robust expression of judicial power. And there is more judicial power in Article 3 than you see in many of the state constitutions. In all the state constitutions that emerged after the Revolution, the judiciary is kind of third out of 3. It's the least powerful branch. It's typically picked by the legislature and doesn't have the same kinds of, in many states, the same kinds of independence that Article 3 will give federal judges. In only one state, Massachusetts, does the Constitution have 3 separate sections of the Constitution for the 3 branches of government, and even then, typically, the judiciary is third and with the least amount of text in that Constitution. So, in the state constitutions, the judiciary tends to be sort of a very weak branch vis-a-vis the legislature. In many of the state constitutions, governors were quite weak. These were state constitutions dominated by the legislative branch. Now, by the time of the Philadelphia Convention, a lot of the Federalists, the supporters of the Constitution, think that these state constitutions are actually bad because they have imbalanced power structures. The legislatures are too powerful, and there's not enough of a check on them. I think of the 39 people who were at Philadelphia, 6 39 signers of the Constitution at Philadelphia. 6 actually had been prominent state or continental judges. And many of the great lawyers of America were at the Philadelphia Convention, and some of them might have imagined that they might be judges under the new system that was being created. And in fact, of the first 6 Supreme Court justices, half of them are members of the Philadelphia Convention, 3 of the 6, and actually of the 5 more that Washington gets to appoint over the course of his 2 terms. 2 more are from Philadelphia. So the framers of the Constitution are creating a robust judiciary in part because some of them imagine that they will occupy this position. But still, and we're going to see that there are some special protections that are built into Article 3, but let's just, again, emphasize it's third out of 3. Let's think about a few ways in which it's still third out of 3, not just textually, in order and in the amount of text, but kind of structurally. So first of all, there's a kind of democratic logic, or kind of just conceptual logic, to the order. First, actually, the legislature has to pass laws, and then they have to be implemented. That's Article 1. They have to be implemented by an executive branch. And then, if people don't like that, cases come to court. The executive prosecutes some people sue. The executive branch sue government, and things come to court. So legislature first passes the law, Article 1. President executes it, Article 2. Court cases arise, Article 3. And that's just kind of a natural order. In 1788, once the Constitution has been ratified, the new government that springs to life is going to materialize in a certain order. First, the Congress has to meet, Article 1. They have to meet first to count the electoral votes. And so only after the electoral votes are counted does the president kind of come on the scene, Article 2, chronologically. And only after both Congress and the president are in place actually, will they be able to pass laws creating actually the judiciary structure? Because Article 3, as we're going to see, does not specify how many judges are going to be on the Supreme Court, how many lower federal courts you're going to have. It gives those decisions to Congress. It specifies there will be one Supreme Court, and such inferior courts as Congress may from time to time ordain and establish, but Congress is going to basically shape the structure of the judiciary to an important extent, and so the judiciary chronologically at the founding materializes third. First the Congress comes on the scene, then they count the electoral votes, and then Washington is summoned, he appears, and then once he's there to sign or veto laws, you can have bills emerge structuring the judiciary. The most important early statute is called the Judiciary Act of 1789. It's passed in September of 1789, and it basically sets up the early judiciary and puts it into operation. And this reminds us of a kind of a larger democratic pyramid that you see in the Constitution. The preamble begins, it's the most democratic, it's the base of this sort of great pyramid with exceptional participation by ordinary citizens, we the people, property qualifications lowered or eliminated in 8 of the 13 states. So the Constitution begins with a very broad popular mandate in the preamble. Article 1, very popular branch of government, Congress being created. Article 2, a little bit more removed from the people, the executive branch, with a more indirect means of election through the Electoral College. Article 3 is the apex of the pyramid, but it's the least democratic, it's furthest removed from the people, and the basic structure of the Constitution is more democratic branches should select less democratic, not vice versa. So, for example, judges don't pick other judges. Presidents pick judges. And judges don't pick their chief justice. Actually, politicians do. In the House of Representatives, the politicians pick their own speaker. The Senate picks their own presiding officer, President pro tem or Senate majority leader. So in the legislature, each branch picks its own leaders. but the judges don't pick the Chief Justice. They don't get to pick that. In the legislature, well, let's take the executive branch. Presidents get to pick cabinet officers, their assistants, but justices don't get to pick lower judges. Each house gets to decide kind of how it's going to operate with rules of its own procedure. But actually, Congress by law can specify many of the procedures of the judiciary, what the rules of evidence are going to be, what the rules of civil and criminal procedure are going to be. Congress even has power to decide how many justices there are going to be, how many lower courts there are going to be. Presidents can fire cabinet officers at will, as we talked about before. Justices can't fire lower court judges at will. So the judiciary has sort of less regulatory power. It to some extent, is under the control of the other more politically accountable branches. So there's like this grand democratic pyramid. Preamble first, it's the broadest base. Article 1 second is the next broadest populous base. Article 2 a little bit less broad, and the judiciary on top. And more politically accountable bodies are picking less politically accountable bodies, not vice versa. That's why many of us, that's a structural reason why many of us actually had some real questions about Bush versus Gore, the Supreme Court case, because under the Constitution, presidents are supposed to be picking judges, not judges picking presidents. So you see the thirdness, how the judiciary is the least dangerous branch. That's a phrase from Alexander Hamilton's Federalist Number 78, one of a series of newspaper op-eds that the Federalists write in support of the Constitution. You see how the judiciary is in some ways the least dangerous branch. Now, Federalist 78 says that judges are going to have the power to refuse to enforce laws that they deem unconstitutional. We call that judicial review, and I think that is absolutely bedrock in our system. Federalist 78 defends that idea. The anti-federalists understood this. Some of them were critical of it, but they understood that judicial review was going to be part of the system. Several state courts had already begun to hold unconstitutional state statutes as violations of state constitutions. So the idea of judicial review was kind of in the air. There was some uncertainty about exactly when and how state judges should do this, how often they had done it. But I think the framers of the Constitution did expect that federal judges would decline to enforce laws that the federal judges thought were unconstitutional, even if the House and the Senate and the President thought that these were perfectly valid laws. Now, remember, that's not a unique power of the judiciary. People in the House of Representatives can vote against the law, and should, that they think is unconstitutional, even if they know the Supreme Court would uphold it. And so too with the Senate. So even today, after the Supreme Court has upheld the Obamacare legislation, it's perfectly permissible for members of the House and Senate to say, we still think it's unconstitutional and we're going to try to repeal it. We're not going to fund it. That's a constitutionally permissible thing for them to do. Now, I happen to think, and we can get into this later perhaps, so that the statute, the Obamacare statute, is not unconstitutional, but our system of government creates multiple checks and balances against an arguably unconstitutional law. The House can vote against it, and if the House votes against it, it doesn't become a law, even if the court would uphold it. And so too with the Senate, and a president can veto it, and he can pardon people who are convicted under statutes that he thinks is unconstitutional. Even after judges have upheld convictions, presidents can pardon people. Thomas Jefferson pardons people convicted under the Sedition Act, even after the Sedition Act of 1798, part of the Alien and Sedition Acts, because Thomas Jefferson thinks that's an unconstitutional statute, even though courts have upheld that statute. So just as the House can basically sometimes be the last word and just say no and make that no stick if the no is we think is unconstitutional, and the Senate and the President, so too with the judiciary. The judiciary has this power to refuse to enforce any law that it deems unconstitutional, to bolster that power, the judiciary is given life tenure, independence from the legislature. Once selected, it's a political selection process. Presidents pick judges, and they can pick them by paying attention to the judge's philosophy. And from the beginning, presidents have attended to likely judicial philosophy of appointees. Washington early on picked only Federalists for the court. And for most of American history, presidents have tended to pick judges that they think support their general vision. And the Senate, too, can confirm judges that they believe have a proper judicial philosophy. So it's a political selection process with the presidency and the Senate. But once the judges are selected, they have life tenure for good behavior in the language of the Constitution. They can't just be sacked as a cabinet officer can if the president decides he doesn't like their opinions. Their salary is undiminishable. It can't go down. It can go up, and that's because since they sit for life, there may be inflation and there may be a need for salary adjustments. But they have, once selected, some independence. And Federalist 78 tells us that one of the most important reasons that they have judicial independence is there is going to be this power of judicial review. They are, on occasion, going to need to invalidate laws or refuse to enforce laws that they, in their own mind, think are unconstitutional. And Hamilton in 78 says when they believe the laws are contrary to the manifest tenor of the Constitution, are kind of clearly unconstitutional, the judges should simply just say no. Now, there is judicial review, but the question is how robust a vision of judicial review did the framers really imagine? Did they imagine judges striking down all sorts of laws all the time, or just occasionally? Did they imagine judges would strike down laws that were only arguably unconstitutional, or instead strike down laws that were clearly and undeniably unconstitutional? Did they imagine that judges would strike down mainly laws regulating the judiciary itself or all sorts of other statutes? So there is judicial review in the Constitution, but what kind of judicial review? How do juries fit into the whole equation? These are some of the questions we're going to talk about in our next lecture, and we'll come back to this picture of John Marshall, so stay tuned. Judges share pride of place with juries. So what's up with that? Why less attention to the judiciary in this walk through the written Constitution? And the answer is because there's less attention in the written Constitution itself to judges. It's Article 3 out of 3. And in fact, there's less text in Article 3. It's the shortest article of the three big ones. The legislature gets the most attention. It's first and longest. The executive is second and second longest. And as I said, the judiciary is third out of 3. And the federal judges who feature up many of the themes of this segment, this chapter, Judges and Juries, many of the themes of Article 3. But before we get to that, you may be wondering why there's only one chapter on the judiciary. Remember that after our chapter on the preamble, the first couple of lectures of this part of the course, we had actually 2 chapters on Article 1, the legislature. So 4 lectures on that. We had 2 chapters, again, 4 lectures on Article 2, the presidency. But we've only got 1 chapter on the judges. And in fact, actually, they have to share that chapter with the juries, as indeed in Article 3, the judiciary involves juries. So one question really to begin with is, why did the Constitution, why did the framers treat the judiciary least and last? Why did they make them third out of 3? And I think the answer begins with the American Revolution. You can't understand our Constitution without understanding our history. Our history as a people is, to a very considerable extent, the history of our wars, and the Constitution is a reflection of our wars. The original Constitution is a reflection of the American Revolution, as we're going to see prominently in Article 3, actually have to share the stage with juries, who can be seen, as we're going to talk about a little bit more, as the lower house, in a sense, of a bicameral judiciary. So just as there's a bicameral legislature with an upper house, a Senate, and a lower house, the House of Representatives, are kind of a bicameral judiciary. With the upper house of judges selected in more refined ways, a small group of rather elite folk, and the lower house, a more populist house, corresponding perhaps to the House of Representatives, the lower house of the framers' judiciary, at least, of the original Constitution's judiciary. Welcome back. Today we're going to begin a discussion of Article 3 of the Constitution, the judiciary article. The discussion that we're going to have in this session and the next one corresponds to Chapter 6 of the book, America's Constitution, a biography. The chapter is called Judges and Juries, and it opens with a picture of the famous John Marshall, the great John Marshall, perhaps the greatest Chief Justice in the history of the United States. And in the next session, I'll tell you a little bit about this picture and how it sums